Good morning. It is 10 a.m. on Tuesday, June 10th, and I'd like to call to order the board meeting for the Tennessee Board of Funeral Directors and Embalmers. As we begin the meeting, I'd like to bring to your attention there's a sign-in sheet on the table by the door. And for anyone that'd like to make comments about an agenda item, please indicate so by your name as you sign in. Any public comments will be accepted near the end of our board meeting. Ms. Bohannon, would you call the roll, please?
Don Haynes.
Here.
Chris Lee.
Here.
Randy Nash. Wendell Naylor.
Here.
I'm sorry. Scotty Porsche.
Here.
Pam Stevens. Tim Willer.
Here.
Mr. President, we have a quorum.
Thank you, ma'am. First thing on the agenda today is we need to have a motion and a second to adopt the agenda. And for the folks that are here virtual, anything that we vote on today will be a roll call vote.
Mr. Lee.
All right, do I have a motion on today's agenda?
Mr. Lee, before we begin, I do need to read in the statement of necessity. So this is an in-person scheduled meeting of the Tennessee Board of Funeral Directors and Embalmers, with 2 members required for quorum participating electronically. Notice of this meeting was posted to the board's website on Monday, October 7th, 2024, and this month's agenda was posted on Monday, June 2nd, 2025. As there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to Tennessee Code Annotated Section 8-44-108B2, which states, quote, "If a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists," end quote. The determination must include a recitation of the facts and circumstances on which it was based. Further, Tennessee Code Annotated Section 8-44-108A3 defines necessity as, quote, "Matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary," end quote. As stated, this is a previously scheduled meeting of the Tennessee Board of Funeral Directors and Embalmers, where 2 members required for quorum are meeting electronically via Microsoft Teams. The purpose of this meeting with members attending by Microsoft Teams is to conduct regular business of the board, including but not limited to the legal report, the executive director's report, and a rulemaking hearing. All voting will be conducted by roll call vote. Would need a motion to adopt the statement of necessity.
Move to adopt.
Second.
I have a motion by Mr. Haynes, a second by Mr. Wheeler. Ms. Bohannon, would you call the roll, please?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens. Ms. Stevens.
Can you hear me?
Yes, ma'am.
Lisa, can you hear me?
Yes, ma'am.
Can you hear me? Yes.
Okay. Tim Willer.
Yes.
Mr. President, the motion passes.
Thank you. First thing on the agenda, we'll go back, is the adoption of today's agenda. I'll accept a motion and a second on that.
So move.
Second.
Have a motion on the floor by Mr. Wheeler and a second by Mr. Haynes to adopt today's agenda. Ms. Bohannon, would you call the roll, please?
Don Haynes.
Aye.
Chris Lee,
Yes.
Wendell Naylor,
Yes.
Scotty Porsche,
Yes.
Pam Stevens,
Yes.
Tim Willer. Mr. President, the motion passes.
Next on the agenda is the public rulemaking hearing. I will turn this over to Mr. Bryan.
Thank you, Mr. Lee. This rulemaking hearing is called to order. I serve as a staff attorney, the Tennessee Department of Commerce and Insurance, Division of Regulatory Boards. With the agency representatives who are present, introduce themselves for the record.
Chris Lee.
Tim Wheeler.
Mr. Naylor, would you introduce yourself, please, sir?
Wendell Naylor.
Ms. Stevens, would you introduce yourself, please, ma'am?
Pamela Stevens.
Mr. Porch, would you introduce yourself, please, sir?
Scotty Porch.
Thank you all very much.
It is Tuesday, June 10th, 2025. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1B of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, and is available by electronic means via Microsoft Teams, which can be located on the board's website, www.tn.gov/commerce/funeral/public-meeting-information.html. On this page, the link for access to this rulemaking hearing via Microsoft Teams can be found in the text box of the meeting, where there should be a link to the red line rule language. The purpose of this rulemaking hearing is to solicit comments on proposed rules of the Tennessee Department of Commerce and Insurance. Regulatory Boards Division and the Tennessee Board of Funeral Directors and Embalmers have made those rules public. The proposed rules update language regarding the acceptance of a high school equivalency rather than only a GED, eliminates obsolete continuing education media, clarifies the standards of online two-way communication between a presenter and a licensee for continuing education, removes reference to potentially outdated URL codes, implements a plan of succession in the event that the executive director position is vacant regarding the receipt of examination grades, and finally increases the clarity of the board's civil penalty range standards. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy, or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date of the rules. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet behind me, located at the desk there. These members of the public wishing to speak and appearing via Microsoft Teams should put their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet or typed their name in the chat box. Is there anyone else who desires to offer oral comments but who have not written their name on the sign-in sheet or typed their name in the chat box? Seeing that there are none, for those attending this hearing in person, I would call to your attention the table located directly behind me. On this table, you will find redline copies of the rule amendments addressed in today's rulemaking hearing. For those attending on Microsoft Teams, again, you can find a link for those rules in the chat box for the redline copies of the rule amendments for today's rulemaking hearing. The notice of rulemaking hearing included the entire text of the proposed rules and was published on the Tennessee Administrative Register website on April 22nd, 2025. Mr. Gribble, what additional notice was given to the affected individuals or groups?
Also, the notice of public rulemaking hearing was published to the website of the Board of Funeral Directors and Embalmers on April 22, 2025. An email was sent to those people who had indicated an interest in knowing the board updates to advise them of the rulemaking hearing. And communication was sent to the Tennessee Funeral Directors Association, representative of the Tennessee State Funeral Director and Morticians Association, and also to the representative of the Cemetery Association of Tennessee and other interested individuals that we were aware of that might be interested in knowing about the rulemaking hearing.
As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. Next, I will read the substance of the proposed rules into the record. First is 10 Comp R and Regs 0660-01-.04 for general provisions, references the department's website and the Federal Trade Commission's website, while deleting the listed URL to avoid obsolete or outdated URL links. Next is 10 Comp R and Regs 0660-02-.021 for grading procedures, adds language that in the event that the executive director of the board position is vacant, the examination grades are sent to the board's administrative manager. The rule is also updated to delete obsolete authority. Next is 10 Comp R and Regs 0660-04-.011B for apprentices. This deletes language regarding GED and replaces it with high school equivalency. Next is 10 Comp R and Regs 0660-05-.011C for funeral directors and embalmers. This too deletes language regarding GED and replaces it with high school equivalency. Next is 10 Comp R and Regs 0660-08-.01 for civil penalties. Deletes the civil penalty chart, listing each section of 10 Code annotated 62-5-317A1 through 9 and 10 Code annotated 62-5-317B1 through 17. Each listed the penalty and assessment of that penalty at, quote, not more than $1,000 nor less than $250. And replaces the chart with language stating that the range of applicable penalties are $250 to $1,000. Next is 10 Comp R and Regs 0660-10-.031 for continuing education requirements, amended by updating the language regarding a continuous two-way transfer of information and continuing education courses to be consistent with the statute. Specifically, the amendment removes reference to the previous manner in an interactive virtual program for continuing education and updates the language regarding a continuous two-way transfer of information between licensee and presenter. And finally, 10 Comp R and Regs 0660-10-.045 for qualifying continuing education programs is amended by deleting cassette and audiovisual presentations as obsolete media for continuing education and updated the sections to compart with the deletion of the first section. Before I take public comment, I will read comments that have been received via email prior to this hearing. To date, I have not received any public comments via email pertaining to the rules for discussion at today's rulemaking hearing. Mr. Gribble, were any written comments received regarding these rules?
There were not. None received.
Okay. Are there any public comments from those present at today's meeting, either in person or via Microsoft Teams? And seeing that there are none, there will be several measures I will need to adopt by motion and roll call vote as required by Tennessee Code Annotated Section 4-5-222. First, I will need a motion to adopt the hearing rules language as amended in the proposed rules. First, for 0660-01-.04.
I'll entertain a motion and a second.
So move.
Have a motion by Mr. Wheeler, a second by Mr. Haynes. Ms. Bohannon, would you please call the roll?
Don Haynes. Chris Lee.
Aye.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens.
Yes.
Tim Willer. Yes. The motion passes.
Thank you, Ms. Bohannon.
Next,
Bryant?
next, I will need a motion for the rule language as amended in Rule 0660-02-.02.
So move.
Have a motion by Mr. Wheeler, a second by Mr. Haynes. Ms. Bohannon, please call the roll.
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens.
Yes.
Tim Willer. Yes. Motion passes.
Next, I'll need a motion to adopt the rule language as amended for Rule 0660-05-.011.
Second.
Have a motion by Mr. Haynes, a second by Mr. Wheeler. Ms. Bohannon, please call the roll.
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens.
Yes.
Tim Willer. Yes. Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant?
Next, I'll need a motion to adopt the language as amended in proposed Rule 0660-08-.01.
So move.
Have a motion by Mr. Wheeler, a second by Mr. Haynes. Ms. Bohannon, please call the roll.
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens.
Yes.
Tim Willer. Yes. Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant?
Next, I'll need a motion to adopt the language as amended in proposed Rule 0660-10-.03.
Second.
Have a motion by Mr. Haynes, a second by Mr. Wheeler. Ms. Bohannon, please call the roll.
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens.
Yes.
Tim Willer. Yes. Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant?
And finally, I'll need a motion to adopt the language as amended in proposed Rule 0660-10-.045.
So move.
Have a motion by Mr. Wheeler, a second by Mr. Haynes. Ms. Bohannon, please call the roll.
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens.
Yes.
Tim Willer. Yes. Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant?
Next, I will read the regulatory flexibility addendum. Pursuant to Tennessee Code annotated sections 4-5401 through 4-5404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rules affects small businesses. The proposed amendments are not anticipated to affect small businesses, and the amendments are clerical in nature. And there are not known less burdensome, less intrusive, or less costly alternative methods to achieving the purpose of these rules. These rules do not create additional requirements for any licensee and are primarily clerical in nature. I will now need a motion to adopt the regulatory flexibility addendum.
Have a motion by Mr. Haynes, a second by Mr. Wheeler. Ms. Bohannon, please call the roll.
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens.
Yes.
Tim Wheeler.
Yes.
Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant?
I will now read the impact on local government statement pursuant to Tennessee Code Annotated Section 4-5-228. There is no foreseen impact on any local governments. I will now need a motion to adopt the impact on local government statement.
Motion to adopt.
Second.
Have a motion by Mr. Haynes and a second by Mr. Wheeler. Ms. Bohannon, please call the roll.
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens.
Yes.
Tim Wheeler.
Yes.
Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant?
Before you is a copy of the additional information required by the Joint Government Operations Committee. All agencies upon filing a rule must also submit the following pursuant to Tennessee Code Annotated Section 4-5-226I1. Please review this document and let me know if you have any questions or concerns. And we'll give you a second to review that, but in the interim, I will now read the answers to the questions required by the Joint Government Operations Committee. All agencies, upon filing a rule, must also submit the following pursuant to Tennessee Code Annotated Section 4-5-226I1. A brief summary of the rule and a description of all relevant changes in previous regulations effectuated by such rule. The Commissioner of the Department of Commerce and Insurance, Tennessee Board of Funeral Directors and Embalmers, intends to propose a new rule regarding the manner in which board information is made available to the public, updated examination and application procedures, organization of civil penalty assessments, and acceptable media for continuing education in compliance with a retrospective rule review completed by the department as required by the General Assembly's enactment of Tennessee Code Annotated Section 4-5-213. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. There are no known federal or state laws or regulations mandating the promulgation of these amendments. C, identification of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. The rule amendments affect current and future licensees as well as applicants. The board anticipates proponents of the rule amendments to include current and future licensees, as the amendments positively impact those within the industry. As most of the rule amendments are clerical in nature, the board does not foresee a segment of opponents to the amendments. D, identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. There are no known opinions of the Attorney General or any judicial ruling that directly relates to the rule or necessitates the promulgation of these rules. E, an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. There is no foreseeable probable increase or decrease in state and local government revenues and expenditures based upon these rules. F, identification of the appropriate agency representative or representatives possessing substantial knowledge and understanding of the rule. And my name and Mr. Gribble's name and contact information has been provided on that filing form. G, identification of the appropriate agency representative or representatives who will explain the rule at a scheduled meeting of the committees. And again, my name and Mr. Gribble's name and contact information is provided on that filing form. H, office address, telephone number, and email address of the agency representative or representatives who will explain the rule at a scheduled meeting of the committees. And again, my name, Mr. Gribble's name, as well as the assistant commissioner's name and contact information is provided on that filing form. I, any additional information relevant to the rule proposed for continuation that the committee requests, and there is no known additional relevant information. Unless any of the members in their review have any questions or concerns regarding those, I will now need a motion to adopt the additional information for the Joint Government Operations Committee.
So move.
Have a motion by Mr. Wheeler, a second by Mr. Haynes. Ms. Bohannon, please call the roll.
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Pam Stevens.
Yes.
Tim Wheeler. The motion passes.
Thank you, Ms. Bohannon. Mr. Bryant?
That concludes this rulemaking hearing. Following this hearing, the rules will be put on a rulemaking filing form SS-7039, submitted to the Governor's Office for final review, and then submitted to the Attorney General's Office for review and approval. Once the Attorney General's signature is obtained, these will be filed with the Secretary of State and will generally become effective 90 days from the date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Thank you all for being here today.
Thank you, Mr. Bryant. If this concludes the rulemaking and we'll be going into our regular meeting, Ms. C, do you want to, I don't want to hold you any longer than you want to be here, but if you want to gather your things, we can move into the next thing. Thank you so much. Okay, board members, next thing on the agenda will be approval of the meeting minutes from May 13th, 2025. And also a reminder, we will need a roll call vote on everything from here on out as well.
Mr.
So,
President, I just want to let you know that Ms. Stevens left the meeting at 10:26 a.m.
it is noted that Ms. Stevens left the meeting at 10:27 hours.
Yes, 10:26.
And we still do
And,
have a quorum with Mr. Porch, is that correct?
yeah, and Mr. Naylor also just left the meeting at 10:26.
Mr. Naylor's gone. Mr. Porch, are you still on?
I am.
Are you going to be able to stay on to conclude our meeting before I get started, sir?
Yes, sir, I'll stay.
Thank you very much. Mr. Naylor, are you back?
Yes.
Okay, are you going to be able to stay as we conclude the meeting as well, sir?
Yes.
Thank you very much. Are we good, Ms. Bohannon? All right.
Yes, sir.
I'll entertain a motion for the approval of the meeting minutes from May 13th, 2025.
So move.
Have a motion by Mr. Wheeler, a second by Mr. Haynes. Ms. Bohannon, would you please call the roll?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Yes. Motion passes.
Thank you, Ms. Bohannon. Next item on the agenda is the legal report. I will turn this over to Mr. Bryant.
Thank you, Mr. Lee. The first complaint is complaint number 2025-021981. This case was administratively opened following a routine inspection conducted on April 9th, 2025. During the course of this routine inspection, the inspector observed the following. Respondent's manager allowed their funeral director's license to expire on February 28th, 2025, and did not meet the requirements for reinstatement until March 12th, 2025. During the unlicensed period, the manager continued to serve in the capacity of manager of respondent establishment despite the expired license. Excuse me. The manager of respondent establishment replied, stating that the lapse was unintentional due to an error in the system, and that upon discovering the lapse, immediately took corrective action. Respondent stated that the system informed them that they had the necessary continuing education credits and that the renewal application and renewal was accepted prior to the expiration of the license. Respondent then states, quote, subsequently, I submitted all necessary documentation to verify my compliance and, in an effort to avoid further delay, promptly completed additional continuing education units to ensure that my credits were fully up to date, end quote. Respondent provided a screenshot of continuing education hours, but was informed by board office staff that they did not reflect the correct expiration date. Based on the above, we'd recommend a $500 civil penalty, authorized via consent order, and a formal hearing if necessary.
Thank you, Mr. Bryant. Any questions? If not, I'll entertain a motion.
I have a question. The system that they're referring. Sorry, the system that they're referring to, are they referring to core or something else?
My understanding is that it is core. One thing I will say is that I think legal's side of core looks very different than the licensee's side of core. So I may defer to Mr. Grimble and Ms. Bohannon on that, but from what I saw, it appeared to be the core system.
I don't know if this answers your question, Ms. Haynes, but on the core side, when you pull up your CUs, they're in no order. You have to maybe search 2 or 3 pages over to find your current CUs. It's a nightmare. But Ms. Bohannon gave me a website, I think it was Verify, and it shows your CUs in order that you have them and how many you have for the license time. So I'm not sure if that's what you were asking, but
And Mr. Haynes, for the benefit of those that might be listening, it's verify.tn.gov, and it'll redirect you to a spot where you can search for any license. And then when you click on details on that license, it'll pull up what Mr. Lee was talking about and show you your CE and all your information pertaining to that particular funeral director embalmer's license or establishment license, whatever it is. But it's verify.tn.gov, and it redirects you to a longer URL.
I make a motion, we accept council's recommendation.
have a motion by Mr. Wheeler, a second by Mr. Haynes to accept council's recommendation. Ms. Bohannon, would you please call the roll?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Yes. The motion passes.
Thank you, Ms. Bohannon. Number 2, Mr. Bryant.
Number 2 is complaint number 2025-022341. This case was administratively opened following a routine inspection conducted on April 9th, 2025. During the course of the routine inspection, the inspector observed the following. The respondent is the manager from the previous complaint. And again, just as a refresher, their funeral director's license expired on February 28th, 2025, was not reinstated until March 12th, 2025. And during that unlicensed period, they continue to serve in the capacity as manager of the establishment despite their expired license. And again, respondent reiterated their response to the previous complaint. Based on the above, we'd recommend a $250 civil penalty authorized via consent order and a formal hearing if necessary.
Thank you, Mr. Bryant. Any questions? If no questions, I'll entertain a motion.
I make a motion, we accept council's recommendation.
Have a motion by Mr. Wheeler and a second by Mr. Haynes to accept council's recommendation. Ms. Bohannon, would you please call the roll?
Don Haynes.
Aye.
Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Yes. Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant, number 3.
Number 3 is complaint number 2025-027951. This case was administratively opened following a routine inspection conducted on April 9th. During the course of the routine inspection, the inspector observed the following. And this establishment is a sister establishment to the establishment in case number 1. An employee of respondent establishment, which is the same individual from case number 2, permitted their license to expire on February 28th, 2025, and was not reinstated until March 12th, 2025. During the unlicensed period, the employee acted in the capacity of a licensed funeral director by making arrangements for 3 decedents. Again, the respondent reiterated their response from the previous responses and provided that screenshot of continuing education hours, but were informed by the board office staff that they did not reflect the current expiration date. So based on the above, we'd recommend a $500 civil penalty authorized via consent order and formal hearing if necessary.
Thank you, Mr. Bryant. Any questions? If none, I'll entertain a motion.
I make a motion we accept council's recommendation.
Have a motion by Mr. Wheeler and a second by Mr. Haynes to accept council's recommendation. Ms. Bohannon, would you call the roll, please?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Motion passes.
Thank you, Ms. Bohannon. Number 4, Mr. Bryant.
Number 4 is complaint number 2025-027961. This case was administratively opened following a routine inspection conducted on April 9th. Again, respondent is the employee from the preceding complaint. During the course of the routine inspection, it was discovered that their license had expired as of February 28th, 2025, was not reinstated until March 12th, 2025, and during that unlicensed period, the respondent made arrangements for 3 decedents. And again, the respondent reiterated their response from the previous complaints. Based on the above, would recommend a $250 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions or comments? If not, I'll entertain a motion.
Motion to adopt council's report.
Second.
Have a motion by Mr. Haynes, second by Mr. Wheeler. Ms. Bohannon, would you call the roll, please?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant, number 5.
Number 5 is complaint number 2025-014881. This case was administratively opened following a routine inspection conducted on March 13th, 2025. During the course of this routine inspection, the inspector observed the following. Respondent's funeral director's license expired on December 31st, 2024, and did not meet the requirements to be reinstated until January 28th, 2025. During the unlicensed period, respondent acted in the capacity of a Tennessee licensed funeral director by signing 6 permits for cremation of human remains as the person in charge of cremation. Respondents stated they did not take part in the embalming procedures, did not engage in making arrangements, conducting funeral services, or any task that would require a funeral director or embalmer's license. Respondents stated the 6 signature permits and that each cremation were all directly supervised by another licensed funeral director. Respondent argued that the cremation permit states, quote, when cremation is complete, the person in charge of the cremation should mail a copy of this form, end quote, and does not specify that the individual in charge has to be a licensed funeral director. Respondent stated they were under the impression that so long as they were being directly supervised, they could perform cremations and, quote, sign as the person who oversaw the cremation. Based on the above, we'd recommend a $250 civil penalty authorized via consent order and formal hearing if necessary.
Thank you, Mr. Bryant. Any questions or comments?
I do have a few questions. On this, by signing off on 6 cremation permits, did the inspector check the statement of goods and services to see who the director was that signed those, and if that corresponded with the permit, I guess is my question.
Yes, and I believe the answer to that question is yes, that I know anytime our inspectors are there, and they always cross-check. So if they're looking at one end on statement of funeral goods and services, oh, okay, this was a cremation, they also check the cremation side and vice versa. So since that was not in the inspector's report, I feel confident that a funeral director signed off on the statement of funeral goods and services, not this individual who was unlicensed at the time. The impression I got from this respondent, I believe the board heard the establishment at last month's meeting, is that they truly tried to do the right thing. And then kind of at the end, the respondent, I think, is correct. You need direct supervision from start to finish on the cremation procedure. But then at the very end, when it says person in charge, that needs to be somebody who's licensed. So it really does seem like they tried to do the right thing and then kind of stumbled right at the finish line. But no other violations were detected or anything that would lead me to believe that this individual conducted more licensed activity with the exception of those signatures.
I make a motion we accept council's recommendation.
Have a motion by Mr. Wheeler and a second by Mr. Haynes Ms. Bohannon, would you call the roll, please?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler.
Yes.
Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant, number 6.
Number 6 is complaint number 2025-019491. This case was administratively opened following a routine inspection conducted on March 31st, 2025. During the course of the routine inspection, the inspector observed the following. Respondent employed a funeral director who permitted their funeral director's license to expire on January 31st, 2025. Excuse me, and did not meet the requirement for reinstatement until February 7th, 2025. During this unlicensed period, the employee acted in the capacity of a funeral director by signing one authorization for cremation form. Respondent replied stating that they were unaware of the licensing violation, providing that the employee had worked for them for over 18 years and that this was the first violation he had received. Respondent stated that they had been shorthanded while the employee was in the hospital and were not aware that the license had expired. Respondent stated they could not undo the violation, but promised to be more diligent in monitoring licensing status moving forward. Based on the above, we'd recommend a $250 civil penalty, authorized via consent order, and a formal hearing if necessary.
I have just one quick question. I was just looking, Mr. Bryant. On this case right here, it's the funeral establishment only. Is there nothing against the funeral director's license?
The funeral director in this was on the previous board meeting's legal report. And I will say, I hate when that happens. And the reason it does sometimes is when they're should be together and they get separated. Sometimes a location will send a response in for both. And our centralized complaint department, not their fault, they just don't know which ones go together. So if one doesn't get a response, it'll get a little bit delayed being recommended to me. And I try and turn these around as quickly as possible. So if the timing is awkward and that happens, it can separate a respondent and an establishment and separate legal reports, which makes it a little more complicated. But yeah, long-winded way to answer your question that yes, there was a civil penalty assessed by this board against that individual at the previous meeting.
Thank you. I just, of course, want to make sure we're consistent with everything. Any other questions, gentlemen?
Yeah, what was the recommendation against them last month? I just want to be consistent with the penalty, I guess.
Let me double check that, but my recollection is that was a $250 civil penalty. I believe this was the one who stated that they were very careful not to do anything, but this was the family that came in and was adamant that they make funeral arrangements right then, right there. But let me double check that to make sure that is the case. Yes, a $250 civil penalty to the individual.
Okay, thank you. I make the recommendation, we accept council's recommendation of a $250 civil penalty.
Have a motion by Mr. Wheeler, a second by Mr. Haynes. Ms. Bohannon, would you please call the roll?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler.
Yes.
Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant, number 7.
Next complaint is complaint number 2025-02771. This case was administratively opened following a routine inspection conducted on April 4th, 2025. During the course of this routine inspection, the inspector observed the following. An employee of a respondent establishment permitted their funeral director's license to expire on February 28th, 2025, and the employee did not meet the requirements for reinstatement until March 10th, 2025. During the unlicensed period, the employee acted in the capacity of a licensed funeral director by being listed as the licensed funeral director on 3 death certificates. Respondent replied stating that they had registered for an in-person class that was worth 7 hours. However, respondent stated the day before the in-person class, a representative called them to inform them that the class had been canceled. Respondent stated they requested an extension from the department but were denied. Following this, they only found 2 hours prior to the expiration, which left them needing 3 hours prior to February 28, 2025. Respondent stated during those 9 days of noncompliance, they did not act as a funeral director. Respondent stated that a death certificate is not a legal document until it has been registered or filed by the county and given a file number. Respondent stated that for each death certificate, they were not registered until March 10th, March 11th, and March 14th, respectively. Thus, as respondent argues, because a death certificate is not official until it is certified, the signature of those certificates was not in license activity because they did not become certified until after his respondent's license had been reinstated. Respondent attached documentation from the CE presenters stated that the event respondent was signed up for had been canceled due to low enrollment. So legally, the death certificate is an official document. While it may not become registered until it is filed, it still remains a legal document at all stages of the proceeding. Specifically, the death certificate states, quote, signature of the funeral director, end quote. When respondent signed the death certificate, they did so with an expired license. While the certificate may have later been filed after respondent signed the certificate and after license reinstatement, respondent still signed the certificate with an expired license and was not legally entitled to sign as a funeral director regardless of when the later filing date occurred. Stated differently, when the death certificate came to respondent at their step in the process, respondent was not properly licensed. Respondent signed the death certificate despite this. Unlicensed activity does not look at the end result of a legal document, but the conduct of respondent at the time of the unlicensed period. Plainly stated, when respondent signed the death certificate as a funeral director, respondent's license was expired. So the recommendation would be a $500 civil penalty, authorized via consent order, and formal hearing if necessary.
Thank you, Mr. Bryant. Is there any comment or questions?
I guess one question, and Mr. Haynes, this might go to you because you are with our continuing ed. Is continuing ed not offered throughout the year? And then I'm just noticing it seems like a lot of these that are letting their license expire are waiting till they find out it's expired, or they wait till the last day to try and get their continuing ed. Can you brighten me a little bit on this?
There's multiple opportunities for continuing education. The Tennessee Funeral Directors Association, you can get 5 hours in the spring meeting, you can get 5 hours in the fall meeting, and you can get, I think, 7 during the annual meeting. Plus, Gupton College offers multiple opportunities for continuing education, in-person hours, and then the NFDA has several programs. So there's really no excuse not to get the Con Ed. Over 2 years, that's correct.
I make the motion we accept council's recommendation for a $500 civil penalty.
I have a motion by Mr. Whaler, a second by Mr. Haynes. Ms. Bohannon, would you call the roll, please?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Yes. Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant, number 8.
Number 8 is complaint number 2025-02781. This case was administratively opened following a routine inspection conducted on April 14th, 2025. During the course of this routine inspection, the inspector observed the following. Respondent's manager allowed their funeral director's license to expire on February 28th, 2025, and did not meet the requirements for reinstatement until March 10th, 2025. During the unlicensed period, the unlicensed manager continued to act in the capacity of manager of the respondent establishment. The manager replied stating that they did not handle any families or work any funerals during the unlicensed period. Likewise, respondent stated that they did not serve any families during that 9-day unlicensed period. So I guess just something to say on that very quickly. And again, if anything I say that the board disagrees with, please, because it's your opinion that matters, not mine. But I think it's good that establishment did not service any families during that time period when you have an unlicensed manager. But the reason for the recommendation, which will be a $250 civil penalty to be authorized via consent order and formal hearing if necessary, is because when our inspector was there was no evidence that, they had closed up shop, weren't accepting phone calls during that time. Let me get my licensing situation scheduled or taken care of, and then we'll open back up. It was just kind of during that period, they didn't do any business, which is good that there's no business being conducted by a establishment that doesn't have a manager, but it's still a violation to have an open and running funeral establishment with a manager that does not have a current license. So that's the basis for the $250 civil penalty recommendation.
Any questions or comments?
I make a motion, we accept council's recommendation.
Have a motion by Mr. Wheeler and a second by Mr. Haynes. Ms. Bohannon, would you call the roll, please?
Don Haynes. Aye. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Yes. Motion passes.
Thank you, Ms. Bohannon. Mr. Bryant, number 9.
Next complaint is complaint number 2025-020171. Complainant alleged that respondent refused to identify the decedent before casketing the decedent and burying the decedent. Complainant alleged that the medical examiner and respondent, quote, conspired together to misidentify their uncle and to bury him as a veteran, even though he was not a veteran, to assist in receiving the life insurance benefits, end quote. Complainant stated respondent was ordered by the Commissioner of Veteran Services to disinter the decedent, and that respondent disagreed to do so. Complainant also alleged that respondent forged a signature from an attorney when sending a cease and desist letter to complainant. Respondent replied, stating that complainant had repeatedly contacted them regarding the disinterment of their uncle to the extent that the corporate office sent a cease and desist letter to the complainant. Respondent denied the allegations included in complainant's complaint, stating that in December of 2019, they worked for an affiliate funeral establishment who was responsible for the interment and was not involved with the burial of the decedent whatsoever. Respondent stated on December 13, 2019, the former manager received an email from the medical examiner's office requesting assistance in burying a homeless veteran in their care. Respondent stated and attached an email as proof of this communication that the medical examiner had identified the individual as complainant's uncle through fingerprint identification performed by the Office of the Federal Bureau of Investigation. Respondent stated the manager agreed to oversee the burial and confirmed the identification based upon information received from the medical examiner's paperwork. Respondent stated this is not their usual method, but due to the circumstances involving an advanced state of decomposition, visual identification would have been impossible, and no friends or family had been identified. Respondent stated the remains of the decedent were in their care for a single day before being buried. Complainant also stated they did not forge the signature of an attorney, and that as complainant's communications became, quote, intense and anything but professional, end quote, they requested their attorney to draft a cease and desist letter and confirmed that the attorney had signed the letter. Complainant provided a rebuttal stating that the cease and desist letter was fraudulent because it was not written with the verbiage an attorney would use, and that the attorney permitted respondent to access his personal data and digital signature. Complainant stated they disregarded the fraudulent letter. Complainant purports to have written proof where respondent agreed to conduct the disinterment, but complainant did not attach these documents to their complaint or rebuttal. In short, complainant stated that it was respondent's responsibility to identify and confirm the identity of the decedent. One of the 2 documents complainant did attach to their complaint was a letter from the Commissioner of Tennessee Department of Veteran Services. The letter approves the disinterment of the decedent, which transferred to a separate cemetery, but states in pertinent part, quote, a representative from the funeral establishment who was responsible for the original interment of decedent, who is interred as other decedent, is required to be on site during the disinterment, end quote. The letter does not state that the funeral home must make the disinterment, but that they must be present. Likewise, the letter states a, quote, representative, not respondent specifically. Respondent has stated that they were only tangentially involved due to working at an affiliate location in 2019 when this occurred. Legal also contacted the office of the attorney who drafted the letter. The paralegal sent an email where the cease and desist letter provided by complainant is attached, being emailed to respondent with the attorney CC'd on the email. The email also states, quote, on behalf of attorney. The attorney's office has confirmed that the letter came from them and was not forged. Finally, if complainant feels that respondent has violated the letter from the Commissioner of the Department of Veteran Services, complainant may proceed through the process of filing a complaint with that agency. It is not within the funeral board's jurisdiction to enforce a letter sent by a different agency. Likewise, legal spoke with an attorney at Veteran Services, who stated that the letter was erroneously sent early, as they are still in the process of coordinating with the medical examiner's office regarding identification of the decedent and next of kin who the decedent may be released to following that disinterment. So based on the above, we'd recommend closure.
Thank you, Mr. Bryant. Any questions or comments? If not, I'll entertain a motion.
I make a motion, we accept council's recommendation for closure.
Have a motion by Mr. Wheeler and a second by Mr. Haynes. Ms. Bohannon, would you call the roll, please?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Yes. The motion passes.
Thank
you, ma'am. Mr. Bryant, number 10.
Next complaint is complaint number 2025-019531. This case was administratively opened following a routine inspection conducted on March 27th, 2025. During the course of this routine inspection, the inspector observed the following. Respondent's website indicates that an unlicensed individual is listed as general manager. Likewise, the individual's business card identifies them as general manager. Respondent stated to avoid confusion, they have denoted on the website that the employee is not a licensed funeral director or embalmer. So after review, the pertinent statute is 62-5-314, which provides that, quote, the name of any living person who has not been licensed as provided in this chapter shall not be shown or displayed upon any funeral establishment, so as to give or tend to give the impression that the person is licensed or entitled to practice either as a funeral director or embalmer. On the page for the employee, the website states, quote, with over 20 years of customer service experience, employees dedicated to providing the highest level of care, treating every family as if they were his own. He is thrilled to be part of this wonderful company and extends his heartfelt gratitude for entrusting us with the care of your and your loved ones during your time of need. The business card also states the individual's name, their title as general manager, the address of the location, office, and cell numbers, and the email address, along with the company logo and motto. Based on legal's review, it is incumbent upon the establishment to make abundantly clear to the consumer that an individual is not a licensed individual. Arguably, the employee's information may not have risen to the level in the statute, but conversely, it would have been a reasonable assumption for any consumer to make that the employee was a licensed individual. Respondent has since taken steps to make the employee's lack of licensure clear to the public and to potential consumers. So based on the above, we'd just recommend a letter of warning.
Do they have a licensed general manager?
They do not. It is the general manager is not a licensed individual, which the law does not require. If you're a manager of the establishment, you do need to be licensed. But as kind of a corporate structure, licensure is not required. But what is required that if you're outwardly facing it to just be open and obvious to the consumer and the public that you're dealing with someone who is not a licensed funeral director.
So question for council. So just based on the previous history of this establishment, I'm looking and we see there's already unlicensed activity. They've received a letter of warning and stuff like that. So I guess my question is, how did you come up with what was your reasoning for the letter of warning?
So I think from there, I don't know that the fear necessarily is of unlicensed activity. My understanding with this establishment is that the general manager doesn't handle the day-to-day. He's not there making arrangements or speaking with families or anything like that. They're over kind of the more bigger picture. I understand that there are a few locations in this geographic area that they are general manager for. So the letter of warning, because if there was a concern regarding the outward, hey, this is someone who works for this company that families probably aren't going to be dealing with directly anyway. But if you do, I wouldn't say that they're giving the impression that he is licensed, but they're not saying, hey, he's not licensed, just so you're aware. So they took steps to fix that. They put on the website now denoting specifically this individual is not a licensed funeral director. But again, from the inspection, there was no evidence that, he's been signing documents, meeting with families, committing any unlicensed activity to that nature. this was more of just a concern about the transparency of if he somehow did happen to come in contact with a family, could they reasonably assume he was a licensed individual? And if so, are there steps that can be taken to prevent that from happening? So that's the basis for the letter of warning.
And have they pulled the business? Is that some, because I know it states his business card. The business card also states the individual's name, their title as general manager, and the address and location. So that's not necessarily illegal, is that correct?
That's correct.
But it was the website that gave the impression that he was licensed.
And I don't know that I'd even go that far necessarily. I guess you can read that blurb, and I guess where I'm at is if I'm just a normal consumer that does not have a lot of interaction with the funeral industry, if I read that blurb, do I think he's a licensed funeral director? Maybe. I don't know that it would occur in a way to where harm would come to the consumer. But I guess whenever you're dealing with the public, it is always better to be safer than sorry, just to be sure that you denote that this individual isn't licensed if somehow that misconception could ever come up. So with that blurb now specifically denoting, just so you're aware, he's the general manager, he's not a licensed funeral director, I think that alleviates a lot of the potential concern. And the letter of warning is essentially to just say, hey, be careful of this moving forward, that we just need to be safer rather than sorry with the public about what assumptions they may jump to regarding licensure.
But the funeral home, as far as licensed with a licensed funeral director running it, they are good.
Yes, they
And
are.
this is like this guy's general manager of a corporation. He wasn't necessarily saying he was general manager of the funeral home.
That's my understanding.
Okay,
Yes.
okay. I got you. Gentlemen, any more questions or comments? If not, I'll entertain a motion.
Motion to accept council's recommendation.
Second.
Have a motion by Mr. Haynes and a second by Mr. Whaler. Ms. Bohannon, would you call the roll, please?
Don Haynes.
Aye.
Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler.
Yes.
Motion passes.
Thank you, ma'am. Mr. Bryant, number 11.
Next complaint is complaint number 2024-054371. Complainant's father of the deceased alleged that respondent had improperly prepared the decedent. Specifically, complainant stated that when they were asked by the hospital to identify the decedent, he, quote, looked as if he was asleep, no marks or bruising, end quote. However, when complainant went to respondent establishment to make arrangements, they were shown a picture of the decedent where the decedent's nose and lips were flat with a smudged mark along his right eyelid. Complainant stated they were told that fluid and positioning can cause features to change. Complainant stated when they saw the decedent in person a week later, he looked the same as he had in the photographs. Respondent provided a very limited response, stating that the complainant did not come forward with any of the concerns regarding the decedent's appearance during the time of the service, and that photographs were shown to the complainant that showed the state of the decedent upon their receipt. Respondent stated that the decedent had been in the morgue for 2 days before they could pick him up, and at times, as with this case, body fluids are sometimes present. This case was ultimately sent for investigation. During the course of the investigation, the investigator did not obtain any information that would conclude that respondent committed a violation regarding the status of the decedent. Per respondent's explanation, the changes in the decedent's feature were due to bodily fluids, and that in the 2 days the decedent was at the morgue following complainant's identification of him, the decedent's features had begun to change. One of the employees of respondent establishment had taken photographs of the decedent of when he entered their care, but had since deleted them as of the day of the inspection. However, the investigator did discover several instances of unlicensed activity during the course of the investigation. In an interview with complainant, the complainant stated that upon arriving at respondent establishment on September 6, 2024, he and his family made arrangements with employee A. Employee A is not a licensed funeral director. Upon receiving a copy of the Statement of Funeral Goods and Services, of which the investigator also obtained a copy, the signature of the funeral director is employee B, who is a licensed funeral director. However, per complainant's interview, neither he nor his family knew who employee B was and had never spoken to them. The investigator also spoke with employee A, who stated that she, employee C, and employee D had worked the funeral, none of which were licensed funeral directors. Finally, employee A stated that following the service, the co-owner, who was a licensed funeral director, and employee C were present at the burial service. The investigator also received a copy of employee A's business card, which states as follows. It included a respondent's establishment name and logo, the company motto, the name of employee A, and the location and website of respondent establishment and 2 phone numbers. The card did not specify employee A's job title. Based on the above, there are 3 clear instances of unlicensed activity. Employee A's handling of the funeral establishments, the 3 unlicensed employee handling the funeral per employee A's own testimony and affidavit, and the signature of employee B on the Statement of Funeral Goods and Services, despite never having met with the family. Arguably, there is a 4th with employee A's business card. Again, the standard for that under the statute is, quote, the name of any living person who has not been licensed as provided in this chapter shall not be shown or displayed upon any funeral establishment, so as to give or tend to give the impression that the person is licensed or entitled to practice either as a funeral director or embalmer. Based on the above, we'd recommend a $3,000 civil penalty plus the cost of investigations related to the 3 instances of unlicensed activity, authorized via consent order and a formal hearing if necessary.
Are there any questions or comments?
I have a question. Is this an isolated incident, or is there evidence that this was kind of a routine situation?
So the only matters that the investigator looked at while they were present were the case that they were there for. And I guess what was concerning is that obviously it feels like a little bit of unlicensed activity happened at almost every step, with the exception of the graveside service. So based on the information the investigator got, we don't have any reason to believe specifically that this is an ongoing, recurring issue, but that is something that is certainly possible. To my knowledge, we've not gotten more complaints against this establishment involving those kinds of allegations. But again, the scope of the inspection was limited to this matter that had been brought up.
Any more questions or comments? If not, I'll entertain a motion.
Motion to approve council's recommendation.
Second.
Have a motion by Mr. Haynes and a second by Mr. Wheeler. Ms. Bohannon, would you call the roll, please?
Don Haynes. Aye. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler.
Yes.
Motion passes.
Thank you, ma'am. Number 12, I believe, Mr. Bryant.
Yes. Next complaint is complaint number 2025-014931. This case was administratively opened following an inspection conducted on March 5th, 2025. Respondent, an unlicensed funeral establishment, appears to be operating an online-only, non-licensed establishment. The website for respondent establishment lists a physical address, but is the address for another licensed establishment. According to the general price list of respondent, there is an affiliation with the licensed location. During the course of this inspection, the inspector observed the following. Respondent establishment did not have a funeral establishment license. Respondent establishment, as an online-only entity, did not have a fixed place of business. On respondent's website, there is an advertisement for a cremation package offering that does not include the individual price of each item. Respondent's website inaccurately states, quote, the law requires the body to be placed in a cremation container for dignified care, respect, and handling of the deceased, end quote. Numerous FTC GPL violations, including the name and address, telephone number did not appear on the GPL. Direct cremation does not list a price. No separate pricing for direct cremation with container provided by purchaser. Only one alternative container is listed in the direct cremation section, but 2 alternative containers are listed in the casket cremation container price list. A cloth cremation casket is also offered as a container for cremation, but is not listed on the casket price list. The amount for the cardboard box / cremation alternative container is listed at $0 in two places on the GPL. However, when looking at the containers section on the website, a price of $85 is indicated and is stated to be included in the package. And on the statement of funeral goods and services selected, the alternative container is listed as a charge of $85 or listed as included in the price. The GPL shows a $0 amount for the alternative container. Other pertinent information found during the inspection. Respondent appears to have serviced 79 individuals through March 4th, 2025. The manager of the affiliated licensed establishment provided a statement providing that they own and operate the licensed establishment, quote, doing business as respondent establishment, end quote. The respondent establishment is online only. Anytime a family had issues with the online forms, it appears they would arrive at the physical licensed establishment and used licensed establishment's paperwork, the statement of funeral goods and services, cremation authorization forms, etc. Respondent replied, stating that prior to this complaint, they had never had a complaint filed against a professional or establishment license, and they have prided themselves in following the rules. The owner stated they became aware the owner of the affiliated location in 2021, and that around this time they were approached by a company that outlined a digital-based model and explained how they partnered with other firms in Tennessee. The owner stated their first question was, "Is this legal in Tennessee?" The representative said that it was, but the owner stated they were still cautious and wanted the board to confirm. The representative claimed that they had contacted the board and confirmed that it was acceptable to operate under a doing business as structure in Tennessee. The owner requested documentation in the name of the person they spoke to verify this conversation took place. Likewise, the owner also personally contacted the state board. The owner stated they explained the proposed setup to the individual they spoke to and received confirmation and moved forward with opening respondent establishment. The owner stated their affiliate location underwent inspections in 2023 without any mention of concern, and that the files were inspected under the physical affiliate name, which they assumed was appropriate since respondent establishment was a doing business as. The owner stated that despite being scheduled for major surgery, when this matter emerged as an issue, they began setting up the process to have respondent establishment license and are in the process of applying for such licensure. In short, respondents stated that they did their best to act in good faith and sought guidance to navigate the situation without making violations, and that based on their conversation with customer service staff, believed that the arrangement was permissible. The owner reiterated that this was not done intentionally or maliciously and only acted upon what they believed to be confirmed and accurate information at the time. Regarding the lack of fixed place of business, the owner stated as soon as they were made aware that their operations were not compliant, they took immediate and proactive steps to address the issue. The owner confirmed an application has been formally submitted to the Tennessee Board to license respondent establishment and that they have undergone inspection and are scheduled for re-inspection. The owner stated further that regarding the GPL, they take full responsibility for the oversight. The owner stated they copied a template from another funeral home's website without carefully reviewing it. The owner stated they have since corrected the identified deficiencies and that an updated version has been provided to the inspector. So it appears, based on the information obtained by legal, that the licensed entity sought to have an online presence and attempted to do so under a doing business as the respondent establishment. However, Tennessee law does not permit a funeral license to extend to other entities. That is, one may not create multiple entities under the canopy of one funeral establishment license. While establishments are free to do, and many do, operate as a doing business as, they are not operating as multiple establishments. They are still utilizing their one establishment license to do business at a singular establishment, not create an online entity, respondent in this case, and a physical entity, the licensed affiliate, to which both may operate as licensed establishments under one license. One license, one establishment. In addition to the licensing and fixed business issues, the online entity had several GPL and FTC issues. Though that they appear they have been corrected, likewise may have been in place for some time prior to that inspection catching them. So based on the above, we'd recommend a $5,000 civil penalty, authorized via consent order, and formal hearing if necessary. And one thing I did want to add, for the benefit of any establishment or anyone listening, when you call the board office and ask what basically amounts to legal advice, I would say not only, I think taking what you were told with a grain of salt is underselling it. I think you should probably, that's asking somebody's opinion as to what the law is, basically. And sometimes you may get told the right thing, and sometimes you may be told the wrong thing. There are methods that are available of which you can do to basically request information such as this, and that method is not to call the board office and kind of run it by someone and see what they think. Generally speaking, as has come up before this board before, and as I mentioned, the board's role is not to provide legal advice to licensees. I understand that's frustrating, but this is precisely why. Because people call, get told something that ends up, the analogy I use is if you say, hey, I've got this problem, it's A, B, and C, what do I do? And they say, oh, okay, here's what you do, that's fine. Well, you didn't know that A, B, and C is true, but D is also relevant. That changes everything. And you never told that person that D existed, so how were they supposed to know? And two, again, you're relying on someone who may not be an attorney for legal advice. So it puts it in a really awkward position where someone, and I will say, in speaking with this respondent, I 100% believe they wanted to do the right thing and did not intend to violate the law, but were essentially told something that didn't comport accurately and now find themselves in a position where a civil penalty is being recommended. I guess the short version for anyone who may be listening on that matter is don't call the board office, ask for legal advice, and then follow it. That's what obtaining private counsel or those other avenues for finding out information are for. So again, would recommend on that basis a $5,000 civil penalty to be authorized via consent order in a formal hearing if necessary.
Any questions or comments?
Just one question. We go to where that in 2023, they underwent inspections without any mentions of concern and that the files were inspected. And so the inspector didn't pick up that this establishment was operating without a license at that period.
So my understanding of what happened in 2023, let's say, because I know it's tricky not being able to use names. Let's say I have a brick and mortar location, Troy Bryant Funeral Home, and then I decide to make an online entity, Bryant Cremation Services. So because Troy Bryant Funeral Home was licensed, the inspector goes to the licensed location, pulls all of our files. They have no idea that Bryant Cremation Services exists online only. My understanding is when this occurred in 2025, the inspector showed up for the usual, inspection at Troy Bryant Funeral Services and asked the manager, hey, I need all your files. And he said, oh, for Troy Bryant Funeral Services or for Bryant Cremation Services? And then the inspector said, what is that? And that's how this
Red
was.
flag went up.
Exactly. So that's why it wasn't caught in 2023, but was caught now.
So I guess my question, they've been in business since 21? Is that the way
I think based on respondents,
when they bought?
that seems to be when conversations begin to happen. I'm not positive what time that online entity actually launched.
Do we know how many services they have completed through this unlicensed establishment?
Yes, as of March 4th, which is when that inspection occurred, 79.
79.
Are they, I guess we would know maybe, are they licensed now or in the process of getting licensed?
They are in the process. They have filed that application, had an inspector come out. They've got, my understanding is, a reinspection scheduled. So they are in the process of becoming licensed.
So my next question, have they completely closed this website down? Is it gone?
I'm not entirely sure. I can possibly check.
Because if not, to me, they're still violating the law.
While Mr. Bryant's looking at that, I'll add, the person who owns this and had a conversation with me after the complaint was filed. And she asked, well, she didn't ask, but she stated, well, I'll quit. I'll just close it up. Well, I can't tell her she has to quit. And that's what I told her. I said, I'm not telling you you have to quit. Just like I can't tell her she can do it, I can't tell her she has to quit. And I'll also say, while Mr. Bryant's looking that up, we went back and reviewed the information that the question was asked to Customer Service Center. And in my opinion, the question, the respondent asked when they called to get permission, which is not, as Mr. Bryant pointed out, that's not the way to do it, but they weren't very clear to the customer service representative as to what they were inquiring about, or it wasn't thoroughly communicated, or at least the customer service representative didn't understand. I think they thought that they were asking, could Troy Bryant Funeral Services LLC operate as Troy Bryant Funeral Home and not operate two separate establishments under one license?
And you make a good point, Mr. Gribble, as did Mr. Bryant, and I think for those that are watching or listening on, that it is not the board's responsibility, it is not Mr. Gribble's responsibility, it's not Ms. Bohannon's responsibility to give legal advice. There are attorneys that are out there, and if you are wanting to do business, you need to get an attorney and follow the law. And there's where I have my problem. They want to call in the office or something like that. Again, you're merely asking for an opinion, and it is not that employee's responsibility to give legal advice because they're not counsel. So on that, I fault, the respondent already doing business should have already looked into the legal aspects of what is required and what should be done to make this legal. So I just want to make that point. You got us an answer, Mr. Bryant?
The website does appear to still be up. If I didn't type in the wrong one, it does seem to. I'm pulling information we had from the inspection, but I believe that the website is still up.
So with that knowledge, I would like to make a motion that we accept council's recommendation of a $5,000 civil penalty, but at the same point with that the website needs to be closed immediately until they have obtained the correct license to operate in the state of Tennessee.
Mr. Bryant, that motion, is that acceptable? Is that?
Yeah,
We're
absolutely.
accepting that, and also, because what we're gathering is they are operating today still without a license. So does that give some teeth, I guess, is what I'm.
Yes, and I can. What I will probably do is on my way home, I will call the respondent, let them know they need to take that down. But usually it takes me less than a week to get the consent order out. But mail, who knows how long it takes to get to them. So.
Well, and the reason I want to add that, because like while we sit here, they're liable to receive a call, and they're operating without a license where all the other establishments in Tennessee have followed the law. So I think it's immediate closure until they come before the state to get their license.
Okay, we have a motion on the floor by Mr. Wheeler and a second by Mr. Haynes. The motion is recommendation of council for a $5,000 civil penalty authorized via consent order and a formal hearing if necessary, and to also contact the respondent and have them shut that website down immediately until license is issued to where it needs to be. Ms. Bohannon, would you call the roll, please?
Don Haynes. Aye. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Yes. The motion passes.
Thank you, Ms. Bohannon. I believe the last item is number 13 is a represent.
Yes, this is complaint number 2022003861. As this was originally written, complainant, mother of the deceased, alleged unprofessional conduct against respondent funeral director. Specifically, complainant stated that scheduling issues continued as respondent informed complainant that there may be a conflict with another service and that respondent may not be able to do the time that complainant had requested. On the day of the service, complainant alleges that respondent did not conduct the funeral as arranged and still could not be contacted. Instead, the wife of respondent conducted the services. Complainant had numerous complaints regarding the provided services, including that respondent's wife was rude, claims she intentionally said the deceased name wrong, and that agreed upon details were not done as requested. Finally, complainant alleged that the deceased was buried improperly and that she and her family had to pick rocks out of the grave and to fill the grave themselves. The wife of respondent replied on respondent's behalf, stating first that they informed the complainant that the selected date had been scheduled for another family, but maintained that the complainant was adamant about that date. Respondent's wife and respondent stated that they are both licensed funeral directors, and in order to meet the needs of the family due to the conflicting schedules, respondent put the wife in charge of complainant's service. Finally, respondent's wife stated that at the graveside, a young man from the family asked if he could use the shovel to place the first few shovels of soil. Respondent's wife stated that she obliged, but that the young man did not return the shovel, and that the family began digging through the soil looking for rocks and gravel. Respondent's wife stated that they continued stating that they wanted a discount for their work. Respondent's wife added that she pronounced the deceased name as it was written and apologized if she misspoke when pronouncing the deceased's name. This case was sent for investigation. The investigator first spoke with the complainant, who stated respondent was unresponsive to her calls from the beginning after the death of the deceased and throughout the week while making arrangements and bringing items for the deceased to wear. Complainant specifically requested that respondent, not respondent's wife, conduct the services because of past negative dealings with the wife. Complainant asserted that respondent assured her he would conduct the services but did not. Complainant stated that respondent's wife was extremely rude and unprofessional to her and the family. Complainant stated that details of the funeral, such as the music and a bracelet to be placed on her daughter, were not used or implemented as agreed. Complainant stated that at the cemetery there was no tent, chairs, or stand for the casket to be placed for the service, that the grave was covered with a blue tarp, and that the family had to remove rocks from the dirt pile and fill the grave themselves. The investigator spoke next to respondent, who stated that he received numerous calls from complainant and paternal grandmother of the deceased regarding arrangements for the services. Respondent stated that when he met with complainant, she requested he conduct the funeral services. However, respondent claims he informed complainant that he had 2 additional services that day and denied that he stated he would be the funeral director for their service. Finally, respondent stated that on the morning of the service, he took the remains to the church, set everything up for the service, and had an employee wait for his wife and the family to arrive. Respondent then left to attend to the other 2 services that he had that day. Finally, respondent added that on the following morning, he went to the cemetery to check on the grave and saw that the grave had been filled and enough room had been left at the top for the city to add sod to the grave later. Finally, the investigator spoke to respondent's wife, a licensed funeral director. The wife stated that while conducting business with the father of the deceased, complainant interrupted them on several occasions and was very upset. The wife maintained that at the cemetery, the dirt did have rocks, and the family did not want the rocks in the grave, so the family removed the rocks from the dirt pile. The wife reiterated that a member of the family asked to place the first shovel of dirt on the grave, but would not return the shovel and begin filling the grave himself. The wife stated that she explained to the family that the cemetery was owned by the city and that a maintenance worker would be by to tamp the grave and to apply sod. The wife denied being rude, disrespectful, or unprofessional to the family, and added that to date, the father, who had agreed to pay for the funeral services, had only paid for half of the bill and informed the wife he would not be paying for any additional money because so many things had gone wrong. At the time, that recommendation was a $250 civil penalty plus costs of investigation, be authorized via consent order and formal hearing. The update: respondent obtained counsel to further explain respondent's position. Per sworn statements from an employee of the establishment and the respondent and his wife, complainant and their family were difficult throughout the process. Although respondent and staff adhered strictly to next of kin decisions during the arrangement conference, many family members would attempt to make suggestions or decisions regarding the arrangements. At times, these would contradict one another. Ultimately, while complainant made all final decisions, respondent stated that the entire family was involved at times to the detriment of clarity. Respondent reiterated that if it was discussed that the family wanted that specific day and time, respondent himself would be unavailable due to an already scheduled service. However, to meet the family's needs, respondent's wife, a licensed funeral director, would run the service. Respondent stated throughout the process, the family was difficult regarding payment details. Respondent stated after some time, the father of the decedent agreed to pay the bill, but that he only paid half of the bill. Respondent stated usually it is their policy to require full payment, but due to the family's loss and in an attempt to help given the situation, accepted half payment with an agreement to pay the remaining funds. Respondent stated to date, respondent has still not paid the remaining costs because reportedly they were dissatisfied with the service. Respondent theorized that many of complainant's grievances were being used as justification for withholding the remainder of the bill. As respondent stated throughout the process, it appeared complainant and their family were looking for things that had purportedly gone wrong. Respondent stated that they implemented all requests from the complainant as they were agreed on. And finally, respondent stated they are not seeking the remainder of the funds through civil proceedings and have let the matter go. Legal has attempted to contact complainant on numerous occasions regarding this updated information. To date, legal has still been unable to speak to complainant regarding the new information. Likewise, when this matter was originally presented, it appeared as a very he said, she said matter where the weight of the evidence weighed slightly in favor of complainant, who had provided several affidavits from family members. While many of these affidavits lack detail or specifics, the evidence supporting complainant's version of events slightly outweighed respondent's supporting evidence. Following retainment of counsel and the subsequent evidence supporting respondent's sequence of events, in legal's view, the weight is now equal, if not slightly supporting respondent due to additional detail not present in many of complainant's affidavits. Compounded by the fact that complainant has been unable to be reached and uncertain if they would cooperate if the matter moved forward to a formal hearing, legal recommends that the matter be closed.
That again, Mr. Bryant. One every meeting. Any questions or comments? If not, I'll entertain a motion.
I make a motion, we accept council's recommendation.
Have a motion by Mr. Wheeler and a second by Mr. Haynes. Ms. Bohannon, would you please call the roll?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Yes. Motion passes.
Thank you very much, Ms. Lisa, and Mr. Bryant, thank you for your report as usual. Next thing we have is the Executive Director's report. Mr. Gribble?
Mr. President, I want to thank you and the two board members who are here physically today, and also thank the two that are still on virtually. Because of their circumstances, they've taken extra efforts to be here so this meeting could be conducted. And I'm going to respect your time and tell you, I'm going to give you a abbreviated report, and if you have questions, I'll expand upon it. But the license have been issued May 6th through June the 6th as reported to you, and consent orders have been accepted as reflected on the April 2025 Regulatory Board Disciplinary Action Report. And the complaint numbers as of June 4, 2025, we had 74 complaints, 42 against funeral directors and or embalmers, and 32 against establishments. Mr. President, unless you have questions, that concludes my report.
Thank you, Mr. Gribble. If there are any questions or comments, if not, I'll accept a motion to accept the Executive Director's report.
I make the motion, we accept Mr. Gribble's report.
Have a motion by Mr. Wheeler and a second by Mr. Haynes. Ms. Bohannon, would you call the roll, please?
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler.
Yes.
The motion passes.
Thank you, Ms. Bohannon. Are there any applicants to appear before the board, individuals or establishments?
There are none, neither individuals nor establishments.
Is there any new business that needs to come before the board? I see none. Ms. Bohannon, does anyone sign up for public comment?
No, sir.
Okay. Before I jump to it, is that all we've got before I ask for an adjournment? Okay. Before I do, Mr. Porch, Mr. Naylor, thank you guys so much for doing what you did today. It helped us get a lot accomplished, even though you're not here. And hope to see you next month, and we appreciate you guys.
Yes, sir.
Thank you.
You're welcome. And the last thing before I go, had a little birdie tell me this, but Mr. Gribble, I think you received a 50-year plaque yesterday. That says a lot. And I wanted to, on behalf of myself and the gentleman here, congratulate you and thank you for what you do for the state, the board, and especially us. And congratulations, sir.
Thank you, Mr. President. I made the comment to Taylor Moore, who presented it to me yesterday. I said, Taylor, I never thought I'd get this old. And someone graciously said that I started when I was 12 years old, which is not true.
Board members, staff, thank you for everything. I'll entertain a motion to adjourn, and as of now, our next meeting is July 2025, and I'm sure we'll know in plenty of time before then if we need to meet or not. Do I have a motion?
So move.
Second. Second. All in favor, respond by saying aye. Roll call again. Roll call, Ms. Lason.
Don Haynes. Chris Lee.
Yes.
Wendell Naylor.
Yes.
Scotty Porsche.
Yes.
Tim Wheeler. Yes. The motion passes.